I'm Dr. Jeff Kieliszewski, forensic psychologist. Welcome to my YouTube channel on forensic psychology. By now, I'm sure many of you have heard of or read about the mass stabbing that occurred in Traverse City, Michigan over the weekend. A man, apparently at random, started stabbing customers in a store. 11 people were critically injured. Luckily, no one has died. Other patrons of the store subdued the suspect out in the parking lot until police arrived. The suspect has been identified as 42-year-old Bradford James Gill. There's been a lot of information that's starting to come out about the suspect. Reportedly, Gill has a history of assaultive behavior. He also has a long history of mental health treatment and mental health difficulties. In fact, he was once arrested for digging up bodies out of graves. So, looking at the random nature of the crime, the method and the circumstances of the crime, and what we're learning about the suspect's history, we likely have a case where there are going to be forensic legal questions requiring a forensic psychological evaluation. Now, from the perspective of a forensic psychologist and what we know about the case so far, there are basically four types of forensic questions that could possibly come out of this case. The first one is the question of possible insanity or a lack of criminal responsibility. When doing a forensic evaluation pertaining to insanity, the forensic psychologist is trying to answer a question based on a statute. The question for insanity becomes, at the time of the alleged offense, was the defendant suffering from a mental disease or defect, and that's typically described as a mental illness or intellectual deficits, where they lacked the substantial capacity to recognize the nature and consequences of their actions? Did they have the ability to recognize between right and wrong? Or, because of the mental disease or defect, they could not conform their behavior to the law at the time of the alleged offense. Now, the bar for insanity in court is very high. Insanity pleas are only raised in about 1% of criminal cases. And when it is raised, it's only effective maybe 25% of the time. So it's very rare to see a not guilty by reason of insanity be successful in court. The second potential forensic question we could see in this case is competency to stand trial. Statutes pertaining to competency to stand trial result in the forensic question, is this person currently impaired by mental disease or defect to the point where they do not have an appreciable understanding of the nature and objects of criminal proceedings, or that they would not be able to assist in their defense. Now, if someone is found not competent to stand trial, typically the examiner must provide an opinion in regards to the substantial likelihood someone could be restored to competency within a specific time frame outlined in the statute. So in Michigan, you have to make an argument the person could be restored to competency within 18 months, for adults at least. Now, restoration could be court-ordered mental health treatment, typically court-ordered psychotropic medications, or specialized education intervention, and this typically occurs with individuals who have intellectual deficits. Now, the third forensic question that could occur in a case like this is diminished capacity. Now, this presents the forensic question of, at the time of the alleged offense, was the defendant impaired by mental disease or defect where their ability to form intent was impaired? This basically means were there symptoms of mental illness or intellectual deficits that directly affected the person's ability to make willful choices, specifically pertaining to the alleged criminal behavior. Now, in most states and in federal law, diminished capacity can only be utilized in sentencing. In other words, the court has to take the diminished capacity into account during sentencing, not pretrial. Now, not every state has a diminished capacity statute. In fact, this will not come into play in this case because Michigan got rid of their diminished capacity statute several years ago. The fourth forensic question that could come into play is a plea for guilty but mentally ill. Now, this statute basically says that the defendant is pleading guilty, but they argue they're suffering from mental illness that was occurring at the time of the crime. Now, courts can take this into account in sentencing. Now, there are only 12 states that actually have a guilty but mentally ill statute. Michigan is one of those. A lot of times in these statutes, there's also a provision that mandates that the person, when they're sent to prison, they are sent to a prison mental health treatment facility rather than general population. So it'll be interesting what happens in this case. If the subscribers know, I'm on Crime Stories with Nancy Grace quite a bit, so I wonder if she'll cover it. Also, this occurred about 2.5 hours from where I am now, and I've done a lot of work in that county, so wouldn't be surprised if I got a phone call and possibly I was appointed on that case. So if you're interested in this topic, please pass this link along to others. Subscribe to the channel. I'm also on other social media outlets, TikTok, Facebook, Instagram, and X. Everything's under Dr. Jeff Kieliszewski, forensic psychologist.